Hi, so I'm Rachel. I'm going to be responding to video thread prompt 2, which was, should future dangerousness risk assessment tools and techniques be admissible in court, and the following the related questions. So while I think there's some importance to understanding and determining which individuals will be repeat offenders, I believe it's vital to consider the merits of each assessment tool prior to admitting them in the courtroom. So this is especially important as a result of a risk assessment may influence decisions regarding parole, sentencing, and bail, and these decisions directly influence the individual's freedom and future in a substantial way. Potential errors that occur via these tools should also be well understood prior to their inclusion as evidence in the courtroom, whether these errors be false positives, false negatives, or any sort of biases included. So additionally, these biases, or any that are included in the tool, should be acknowledged and disclosed to those who use it, including judges, prosecutors, and defense attorneys. So overall, because these tools have been shown to have low accuracy rates and racial biases that result in higher risk ratings for black defendants as compared to white defendants, the inclusion of them in the courtroom is questionable. So in the reading provided in this module, the relative lack of empirical study on assessment tools was highlighted, although the study by ProPublica demonstrates some independent assessment of techniques used to predict recidivism. So when evaluating these techniques, we should look at the validity and accuracy of the tool, among other factors. So in the ProPublica study, the COMPASS risk assessment technique was shown to have a low accuracy rate of only 20% when evaluating violent offenses, and only a slightly better than chance accuracy for non-violent offenses. So this suggests that the tools are not incredibly useful in terms of incorporating them in sentencing decisions, and it demonstrates that they have relatively low validity. So this conclusion is also supported by the results of Dressel's research in the YouTube video that we watched, wherein human risk assessment was only slightly less accurate than COMPASS. And because human accuracy is not entirely that great, it's only 65% or around that, at least in her study, this demonstrates that it's not necessarily a useful tool. So furthermore, I think that when we argue for the inclusion of a particular technique in the courtroom, these arguments should relate to the current standards in place for evidence admission. So in particular, if we view tools such as COMPASS through the lens of the Daubert criteria brought up in Chapter 4 of the Lilienfeld textbook, these tools fail to provide substantial evidence of peer review and known error rates. So as noted in the reading entitled Machine Bias, only a few studies have been conducted investigating the validity and error rates of each of the 19 risk assessment techniques, which suggests that further analysis should be conducted before these tools are included in court decisions. Furthermore, while error rates have been demonstrated in a few studies, such as ProPublica's study, these error rates are relatively high and have racial biases that are not disclosed to judges that employ these tools in sentencing. So it's highly important to also note and describe the way that these assessment tools may be biased in certain directions, as with the racial bias and potentially some gender bias. So, for instance, with black defendants getting higher risk ratings, which could result in these individuals receiving harsher sentences, despite these recommendations potentially being a false positive, because as the ProPublica study noted, it was more likely for black defendants to get a false positive rather than a false negative, whereas white defendants tended to have more false negatives than false positives. So the textbook notes that the use of risk assessment tools is not entirely detrimental, and I agree that we should be considering to some extent the likelihood that an individual will repeat a crime in the future. So, for example, if a person has a long list of previous similar crimes, it's intuitive to suggest that the sentence should vary, or that the individual may go on to repeat the crime again. So as noted in the YouTube video, Dressel demonstrated that the two factors that were found to have the same accuracy when put into a regression analysis, I believe, were age and previous offenses. So I think that it's intuitive to believe that, both from a human perspective and also from a data perspective. So with all these considerations in mind, it might not be essential to remove all forms of risk assessment from the courtroom, but instead provide such information with the explanation of the potential flaws. So judges should be provided with the means of critically analyzing the information and evidence that they're given, such as the number provided for the risk of a particular defendant, which is provided by COMPASS. So risk assessments could be beneficial in providing suggestions for the resources an individual might need, to help reduce the likelihood of a repeat offense. So in this way, it would be used to suggest certain treatments, certain programs that could be implemented with a specific individual, rather than determining how long a sentence should be or what the bail should be set at. Additionally, if these techniques are to be included in the courtroom, I believe that the defendant should be given the opportunity to cross-examine the results and provide information on error rates and racial biases within the test. So, they should also be provided with information resulting from that risk assessment prior to sentencing, such that these concerns regarding the assessment tool can be highlighted during the sentencing procedures and thus influence sentencing more directly. If expert testimony is allowed in on these tests to say, hey, this risk assessment is high for this person, and therefore they might have a higher risk of committing the same offense later, I do believe that the defense should have the opportunity to present counter evidence and have an expert that shows the potential flaws in the assessment as well. So it shouldn't be a one-sided, hey, this is the data that we found from this study or from this assessment technique, and go and do it with it what you may. It should have both sides presented so that the judges can make better and more informed decisions. So overall, I don't believe that risk assessment tools should be admissible in court for sentencing decisions, although they may be able to have some benefit in providing some additional resources to those who have a higher risk of committing the same crime. So I don't believe that they should be incorporated because of the various flaws that accompany them and the low accuracy that that was found in the ProPublica study, among other studies. And I believe that also the racial bias that's shown, whereas with black defendants having higher false positives, I think that those should all be considered reasons why this risk assessment tools might not be should not be incorporated in courtrooms. So this doesn't mean that there's no place for risk assessments in courts, but instead reflects the low validity shown through studies on the accuracy of the techniques. And I don't believe that we should allow techniques that haven't been subjective in general to proper empirical evaluation to be involved in determining the future of an individual.